Welcome to Trial Think, the podcast of Kenney Sams. In each episode, our team of nationally recognized litigators and industry experts discuss how the lessons they learned before, during, and after trial can be used to reverse engineer best practices for attorneys, clients, and risk managers.
Welcome back to Trial Think, the podcast of Kenney Sams. Joining us today is Chris Kenney, the founding partner of Kenney Sams, and Ed Goddard. Ed's going to offer the perspective on mediation from the client. And Chris, as someone that's got extensive experience both mediating as an advocate and also as a mediator himself, is going to share his perspective. So no surprises based on that introduction. We're going to be talking about mediation. Mediation is a type of alternative dispute resolution that some of you may be familiar with, but others may not. So we're going to go over what mediation is, and we're going to hear these two perspectives that I think are really helpful for folks that are considering mediation and how it's different than full-blown litigation. So without further ado, Chris and Ed, thanks for joining us today.
Good morning, Nate. Thank you.
Thanks, Nate. Glad to be here.
Great. Chris, you've been introduced to our listeners before as one of the founding partners, but can you remind us what your experience is, and in particular your experience with mediation and as a mediator?
Sure, thank you. I'm a local guy, grew up in the greater Boston area, went to school at Holy Cross and Boston University School of Law, which is where I met Ed Goddard, and we've been friends, law partners, and attorney-client relationship ever since then. So I'm delighted to have Ed on with us today. I've done tons of mediations in my 34 years of practice, frankly, dozens with Ed. We were law partners, we did them together, and then Ed was in an executive position with the Fortune 300 company, and he was kind enough to entrust some of his legal work to me, and we had a blast going into mediations where he was the client and I was the advocate, and we would double team, and we want to share some of that experience with you today.
That's great.
Actually,
And
I should also say, excuse me, Nate, I should also say that for the last 15 years, I've been a certified mediator in Massachusetts, and I've done dozens of mediations as the mediator, and I really enjoyed the experience. I think that my trial lawyer experience gives me insight and perspective that helps the parties to resolve their cases.
that perspective, Chris, as both someone that's mediated and as the mediator is really important. So I'm looking forward to hearing from you and how it's different to be a mediator versus participant on one side or the other in a mediation. So we'll get back to you on that in a moment. Ed, founder and chief administrative officer of Post-Acute Exec HR Roundtable. Did I get that right?
You did get that right, and that's my most recent post-attorney retirement venture, Nate, and thanks to you and Chris for having me on. As Chris suggested, we do go back all the way from our days at Boston University Law School. I did my undergrad at Brown University, and then, like Chris, graduated from Boston University School of Law in 1990. I then clerked for the Supreme Court in Rhode Island for a year. Having grown up in Rhode Island, it was like a homecoming. After that, I traveled out to San Francisco, where I practiced labor and employment law for Littler Mendelsohn, the largest labor and employment law firm in the country. Coming back to Boston, I was with a large firm in Boston for a few years before joining Chris, where we had a good several-year run, a lot of fun, and two young attorneys in Boston trying to make our way through. Following that, I went to Kindred Healthcare, which at its height was more than $6 billion in revenue and more than 100,000 employees. And so I ended my run with Kindred, my 24-year run with Kindred at the end of 2022. And after that, Nate, have a couple of business ventures, one of which is now the Post-Acute Executive HR Roundtable, which essentially is a best practice group for senior HR executives in the post-acute healthcare field. I do have a lot of experience, as Chris intimated, with mediations, both being as an advocate, but also being a client. And I think I do bring a unique perspective as a client, and I think people who are clients in large organizations or in smaller organizations maybe view mediation differently. And so I'm interested in having those discussions with you all today, and hopefully some of the listeners can gain some insight.
Great. Really appreciate you spending time with us today, Ed. So let's start at the beginning here with mediation. We've all been a part of it. I know that I've been a part of probably coming on 100 plus mediations over the years, but you guys have a lot more experience. Chris, what is mediation and how is it different from litigation or other types of dispute resolution?
So mediation is essentially a structured settlement negotiation where the parties, the combatants, decide that they're going to put their weapons down and jointly retain a trusted neutral party to sort of referee a confidential settlement discussion. The mediation is three things that make it effective. It's voluntary, the parties come together because they want to, not because they have to. It's confidential, which means that people can speak candidly and really negotiate and show their cards, knowing that if the case does not resolve, everything that was disclosed is confidential and won't come up in a trial or arbitration. And it's non-binding. In other words, you can take a run at settling the case. If you're unsuccessful, there's no downside risk. So it is in those three respects very different from the two other principal means of dispute resolution, which are litigation through the court system and arbitration, which is a binding form of dispute resolution. Mediation is sometimes used as a mid-step settlement approach before going to the dispositive proceeding of a trial or arbitration.
Given that, is there any reason not to mediate before you go to trial or even before you file litigation? When is it appropriate? When is it not, Chris?
Well, that's a good question. I'm actually interested in hearing from Ed as well. But from my view, having done hundreds of mediations over the past 3 decades, I think there's very little to almost no downside to mediating a case. Of all the civil lawsuits that are filed in Massachusetts, over 90% resolve without a trial. Now, some of those are dismissed, but most of those are resolved through a voluntary settlement. When you have the two trial lawyers negotiating, they are champions, championing their clients' respective cases. So sometimes it's inefficient and impracticable for them to resolve the case because they both are advocates. That's why mediation is so effective at resolving cases. You have this neutral third party to filter information through, and your clients can hear from the other side an unfiltered view as well in this confidential setting.
Ed, do you agree with that? I mean, as a client, do you not just want your proverbial day in court and let the lawyers duke it out, or is there this alternative path that has worked for you, and if so, how?
Yeah, Nate, Chris is spot on in his analysis. I actually think that mediation is underutilized. Far too many times the combatants, to use Chris's phrase, get invested in the process and they lose sight of what the goal is, and the goal is to have a mutually beneficial end to whatever the proceeding, whether it be an arbitration or whether it be litigation. I would say that the one caveat, and we'll probably discuss it more, is there is a certain cadence to cases that mediation fits in at the appropriate time. You can't go to mediation too early, in my opinion. People's emotions need to cool. The case needs to have some moderate discovery, even if it's in an arbitration forum, where if you get there at the initial stages because you want to rush to settle the case, it's usually not successful because the parties aren't settled enough, to use that phrase in a different context, to be able to speak reasonably and both looking for a win-win. And so I guess I would add, I'm not disputing anything Chris said, I would just add that I think the timing of mediation is critical to its success.
You think that
as well. Go ahead, Nick.
Go ahead.
I was going to say timing is important because you'll see sometimes, and I've seen this when I serve as the mediator, is that if it's too early, if it's before suit's been filed or suit's been filed but no discovery's been done, then the parties still have counterpoint allegations. Nothing's been locked in under the pains and penalties of perjury in a deposition or an affidavit. So it's less efficient because people are still at the essentially pleading stage. Once you've been in some discovery and people have been locked in deposition transcripts, there's less wiggle room, and you know what is going to be undisputed at trial.
Yeah, Chris, and I think the other point I was making on that, though, is also there's usually less emotion as the case goes on, and particularly if in employment context, many of my mediations have been employment, and when the suit or arbitration is first filed, there's a ton of emotion, especially from the plaintiff side, but not exclusively from the plaintiff side. And sometimes when it gets 3, 6, 9 months and a year, some of that initial emotion has worn down, and I think both sides can be more reasonable.
Chris, do you think that it's less about sort of the emotional component decreasing, or more about the fact that as you mediate later in a case, you now have just objective facts, the testimony that you spoke to, that allows that to sort of combat the emotion that one or more of the parties may have? Or is Ed right, that emotion comes down? I'm just curious your thoughts on where that fits in with your point about mediating later in a case where you've got some hard and fast evidence to be able to push back on the emotional responses.
I think it's a confluence of factors. Later in the case, you have less uncertainty, but more expense. Parties are saying, my goodness, I've spent this much to get toward trial, and how much more am I going to spend to get to trial and through trial? And do I have a guarantee I'm going to win? Or am I going to just entrust this to 12 strangers in a jury box? So that's an important thing, is people are more aware of the expense, and it becomes a factor in the decision-making longer you're in the case. Ed's right that emotions are a huge component of settling a lawsuit. Sometimes mediation is called conciliation, and in that respect, it's effective sometimes to be conciliatory as an advocate at mediation. Mediation is not an opportunity to go and poke the other side in the eye. That's counterproductive. Being a gratuitous jerk is just not an effective legal strategy. If you're going to go to mediation, the objective to achieve for your client is to resolve the case on satisfactory terms. Your opponent has the exact same marching orders. The only thing in dispute is what are satisfactory terms. But again, to win at mediation means that you've achieved your client's objectives, and that means you have to be aware that there may be hot emotions. And as an advocate, you've got to modulate your approach, sort of temper it, in a way that's going to be effective. My own approach as an advocate is to try to establish a constructive rapport, not just with opposing counsel, but with the opposing parties. Shake hands in the morning, greet them, be professional. My approach normally as an advocate is to provide an opening statement. In some cases it may be counterproductive if it's a horrific accident and the widow's across the table. Perhaps we don't do it there as a sign of respect. But in most cases, business cases, employment cases, it's often helpful to be able to speak directly to the decision maker across the table in a way that they'll hear what the jury would hear, and they can understand that directly rather than having it be filtered through their client.
Chris, help our listeners understand that haven't participated in it. So a mediation, the sort of fundamentals of it are you show up in person, although we've all been a part in the sort of post-pandemic world of remote mediations, and I want to ask you questions about, from the perspective of both of you, whether you think that is as effective as in person. I think I know the answer from you, Chris, but you show up and you've got both sides that are in a conference room, essentially. Walk us through what that process looks like and how a typical mediation starts and then how it proceeds in the course of the day, Chris.
Sure. There's a roadmap that all mediations follow. The first is that you've jointly retained the mediator and you're splitting the cost equally. So everybody's got the same investment in the process. The parties and the lawyers are devoting a day to it. So there's some expense associated with it. But even when the case doesn't settle, that expense helps you to know more about your case. So it's almost always worthwhile. Once you show up at the mediator's office, as you said, Nate, you're normally in a large conference room together. This is stage one. This is what's called the plenary session or the joint session. The parties are on opposite sides of a table, and the mediator is at the end of the table. She or he is not in a black robe and doesn't have the power of a judge, but is really the mutually respected referee and sounding board that the parties have agreed to work with. So the first thing that the mediator does is provide an overview of the process to the parties. Most lawyers have been through mediation, so they don't need that overview. But even just providing it, I think, is helpful for the mediator to establish some rapport with the parties, so the parties aren't uncertain what's going to happen next. The mediator will tell them what's going to happen next, and this is essentially what's said. Everything we talk about today is confidential. We're going to have a joint session here so that the parties can meet each other, and then I will give the lawyers on each side an opportunity to provide a brief opening statement. That's stage two, is the opening statements if the parties and counsel choose to make them. The plaintiff with the burden of proof normally goes first, as in a trial, and provides an opening statement that in most instances is a truncated version of what you'd see in trial. It doesn't have all the bells and whistles. But our own practice at our firm is to make it more of a trial-worthy opening statement than less in most cases.
And by opening statement, you're giving an overview of what you expect the evidence is going to show. And the point of doing that, I guess, is it for the mediator's benefit to educate the mediator, or is it to educate the other side or the client? Ed, you're shaking your head, and I want to ask you some questions about how important it is for the client to be there in a moment. But what is the purpose of the opening statement, Chris?
Well, the opening statement should not be the first time you've educated the mediator. Before the mediation begins, the parties should each have submitted a detailed memorandum outlining their positions. Again, they can choose to exchange them so that both sides know what the other side's deck of hand is, essentially, what their best points are, et cetera. Or they can just submit them confidentially to the mediator, but that should happen before the mediation begins. Otherwise, you have a really cold start at the mediation if the mediator's saying for the first time, what's this case all about? Therefore, the mediation opening statement, Nate, can be much more of a summary. And that's because it's simply building upon information the parties have already exchanged. A lot of the success in a mediation is expectation management. So if you can get your case digested into a memo, get it to the other side so they share it with their clients, and then you come in and give a shortened version of that to start the mediation process off with your opening statement, it really helps to move the case toward mediation, toward resolution without people saying, what's this all about? And I don't understand their position.
So you give an overview, you try to let the other side know, here's how we expect the evidence to come in, you need to consider it. Ed, how important is it for you as the client to be there in person to hear these openings? And are you seeing some folks abandoning the openings and just jumping right into the negotiation? What works best for you from the client's perspective, and what do you benefit from when you hear these opening statements and you participate as the client?
Well, let me go back to something that Chris said earlier, and then I'll get to your question, Nate.
Sure.
One of the reasons I like to use Kenney Sams and Chris in particular is he basically follows the same conciliatory model I do in these, and we'll walk into the room and immediately walk over to the plaintiff and to the plaintiff's counsel, introduce ourselves. Good morning, how are you? Some weather we had today, etc. This is not we hate you because you're here. This is a matter of business, and we're trying to resolve this. And very often, we think we're right, they think they're right, and they're somewhere in the middle. So I do think tone is important. You said a bad tone initially, and it makes your task for the rest of the day to try to resolve it. And Chris is a master at that. I also think in most circumstances, Nate, to answer your question directly, that an opening statement is important. I mean, I've had matters. You have to understand that many of the times when I'm doing this, I will see the plaintiff's counsel again and again and again because they represent one employee, then they tend to represent many other employees. So for me, most of these were not transactional, they were actually relationship. And so it's important that not just for this person, because this person may be going back to work, by the way, right, in my nursing home or in my hospital. So we'll get to that a little bit. I have other client issues that I have to worry about that perhaps in other circumstances clients don't. But I've had circumstances where immediately after the opening statement break, the counsel on the other side pulled me aside because I would know he or she and say, holy cow, where did you get this guy? Right? Because Chris doesn't make it its full opening, but he makes the traditional Chris Kenney opening where people know, one, that we're serious about this, two, that we brought in a heavy hitter advocate, and three, by doing so, that does help counsel on the other side give a more realistic picture to their client that they're going to take this seriously. They have a very strong advocate. He laid out a very strong case, so let's get real pretty quickly. And so those are all important factors, and some of that is, what do I look for in someone who's going to represent me at a mediation, and I think I fairly described that.
So from the client's perspective, I mean, certainly at Kenney Sams, we take mediations and openings at mediations, which are not in vogue for some mediators and some opposing lawyers. I think it's important that you view it as a preview of what to expect if this case goes forward, both in terms of what the evidence is going to show, but also in terms of who your opponent is and who you're going to be dealing with and who a jury is going to hear from. So I think when you speak about what Chris does well and what the firm really works on in teaching our junior lawyers how to approach mediation is using it as an opportunity to showcase there's more of this, more where this came from. And as this thing goes forward, we like to start off the mediations by asking the other side to consider as objectively as they can how a jury, a neutral group of 12 people, is going to hear this information and how they're going to perceive us as advocates. So I think to your point, it really does set the tone, but it's not antagonistic, right? That's so counterproductive. And I think that's where a lot of mediators have wanted folks to move away from openings, because if you're just throwing bombs, then the first half of the mediation is going to be about getting people back to a place where they're even willing to be conciliatory. Is that a fair summary of how to approach those openings?
Yeah, that's a fair summary, and it's critically important. You only get one chance to make a first impression, as my dad used to say. And the first impression is, it's the what is the iron fist inside the velvet glove. These guys are nice guys, but they'll hammer me if they need to. If we don't get this resolved today. So yeah, that's a very fair description of, certainly as I look at it, Nate, from a client's perspective.
Chris, you spoke. We both, all of us, have spoken about the idea of sort of confidentiality that as one part of mediation that's really advantageous. But how can it be confidential if information is being shared about the other side's position and you're sharing your information? How does it in fact remain confidential, or can you put that toothpaste back in the tube once you've let the other side know what your angle is or how you're approaching a case?
Good question. At the process itself, it's protected by a statute mandating confidentiality for mediation hearings. It's also a matter of contract. When the parties hire the mediator, any good mediator is going to require that they sign a confidentiality agreement. And then when you share this information in the confidential setting, it's food for thought. The other side should understand that this is information we expect we could present to a jury. The beauty of mediation is that there are no rules of evidence. So sometimes you can provide a broader sense of the story than might get through the filter of the rules of evidence at trial. But to answer your question, if you disclose something and the other side intends to try to use it at trial, you can bar that through a motion to eliminate or just flagging for the judge that this was something disclosed at mediation, and the judge will, every time, shut it down.
Can the mediator ever get dragged in as a witness to what they're hearing in the course of the mediation and the communication?
The statute doesn't allow it, and the contract doesn't allow it.
Nate, can I talk to that for a minute? And so, as always, Chris goes to the very legal answer, and as always, he's exactly 100% right. I don't think you can ever get the toothpaste back in the tube. And so one of the things that I talked to Chris and others is, again, as I referenced earlier, this employee may be going back to work. Or if he or she is not going back to work, all of their coworkers and friends are still at work. And so we need to be really circumspect in that situation as to a couple of things. One, what we say, right? Because the allegation may be against a member of management who may be running this facility, or a director of nurses, or someone who's important to the facility, and also thereby important to the company as a whole, right? Even as the client, I as an in-house counsel, I represent a large company. And so not only part of what is said, also part of how we settle is important, right? I can't settle a case for $35,000 and then have it go back where people are saying, yeah, and they admitted that so and so did this, and they admitted that so and so did that, and expect that we're going to point to a document that's an NDA settlement agreement and it's not going to get out, right? So there are some, for me as the client, there are some extra legal realities that come up with that, and frankly, as Chris well knows, there are times when me as a client is willing to pay more to get some of those extra protections because they're important to my business on a broader scheme than whether I pay $5,000 or $10,000 more to settle an individual suit.
And how many of these considerations are sort of considered and balanced and evaluated with counsel before you even go into mediation? That is, you don't just show up, I imagine, and sort of wander through and see what kind of results you can get. But there's a lot of strategy before the mediation begins that goes into sort of thinking about how you're going to try and push the other side to a result that is what you're looking for. And that's not just necessarily a monetary outcome. Is that fair?
Well, that's fair, and I'll answer your question directly. With Chris, all of these considerations are discussed. With some other outside counsel who I've used, I hold back a little bit. And that's the reality, is I know I can trust Chris personally, but I also trust his judgment. He's got a great deal of common sense, and he knows what he's doing, and he knows when I say something to him, he understands it. So, for example, if I'll tell Chris my limit of authority, and it won't be I'm holding something in my back pocket. That's not necessarily, being honest, that's not necessarily as a client what I would tell necessarily all of my advocates, because I know that some of them are less inclined to actually go to trial and more inclined to try to use this to settle under any circumstances. So it's easier for me with Chris than it is for others. But I've had other advocates that I'm also comfortable with that I share. It's not Chris isn't the exclusive one, but there are others that I have holdbacks on, and I'm less forthcoming as a client. And I'm sure Chris is. Chris, and probably you, Nate, have probably found the same thing. Geez, I wish you had told me that at the get-go type of approach.
So there's sort of a game within a game. There's the strategy of how much do you share, even with your own lawyer, because you're trying to position the lawyer to fight a certain way. Not all lawyers if given the complete information of what's in your head and where you're looking to go with things, would necessarily approach the mediation in the same manner. So there's a strategy that goes into, even from a client's perspective, how much you are willing to share with the advocate on your behalf, and when in the course of the mediation you share
Yeah,
that.
and one final point, because I know Chris will want to weigh in on these comments. Also, there's also a strategy within my own company, right? I may be telling them that I may think this will settle for 50 grand, but I'll tell them I need 100 in authority, so that when I settle for 50 grand, I look like a hero. So that in larger organizations there are complex strategies that you're always balancing, but more particularly to what we discussed, you're absolutely right in terms of the strategy within the strategy and in what you tell your retained counsel for a mediation.
A lot of moving parts. Chris, from your perspective, as I guess first as an advocate, as someone participating in a mediation, do you want to know what your client's drop dead position is before you go in, or is there some advantage of sort of fighting a fight based on what your understanding is, and letting the client, especially more sophisticated clients, weigh in and take charge as the mediation progresses? What's your preference as you go into a mediation?
I like to know as much as I can so that my client and I are working as partners at the proceeding. I think the success of mediation is based on two factors: efficacy and expectation management. The expectation management is both with your client and, as Ed said, and Ed's internal clients, the people he has to answer to. We want to make sure that we know what their expectations are so we can manage them and meet them. We also want to manage the opponent's expectations. What do they think? We're not going to go out and give them our bottom dollar to start the proceeding, right? So expectation management is a really important process, working with your client and working with the other side, and even with the mediator. The other thing, efficacy, you're coming to mediation to resolve the case if it can be done on satisfactory terms. So everything you do and say should be directed toward achieving that goal. I love that word, efficacy. You think about, am I going to say this a certain way? Am I going to disclose this evidence? Or is it going to be counterproductive? If it's counterproductive, let's not use it. And that just brings me back, Nate, to a point you brought about confidentiality. So the process is confidential, and therefore you can disclose what you want to disclose, but it doesn't mean you always want to, because you're not guaranteed to settle the case at mediation. And if you end up going to trial, you might want to have that smoking gun that has not been disclosed so that you can still win the case. Sometimes you even dangle it in front of the mediator. You might say, listen, Mr. Mediator or Madam Mediator, I'm going to confidentially tell you something. We have a witness who's going to absolutely blow their case away. I'm not going to tell you who it is or what they're going to say, but I do authorize you to go in there and tell them we have that point fully covered. We have two ways of getting into evidence. We're not going to disclose it, but they should just factor that into the decision making.
Okay, and sometimes these are things that you reveal in what we talked about as the plenary session, the opening session. But I want to talk more in terms of the strategy once you're in the trenches of the mediation. So you do your opening, the other side may or may not take up the opportunity to do an opening and share their version of their evidence and what they expect to be able to prove to a jury. I think we've seen it time and time again where we take the opportunity not to antagonize the other side, but to educate and to be able to advocate in a way that I think is effective and gets them thinking, geez, maybe my version of events isn't the one that's going to carry the day in front of a jury. It's a hard thing, especially with individuals that aren't experienced in litigation, to be able to sort of objectively hear the other side, but we take that opportunity. I've seen it numerous times where the other side doesn't, and they're recoiling a little bit after, we've had that experience. I know, Chris, we've talked about it, where they're looking at their lawyer who has not given the opening and taken that opportunity, and hearing it from the other side and thinking, well, why wouldn't you have done that? But you get beyond that process. Once the opening stage is complete, what's the next step in the mediation process, Chris?
So the parties are separated then. You leave the joint session, you're not in the same conference room anymore. Each party and their respective counsel are in separate rooms. And that's when the mediator earns her money. She goes back and forth to these private sessions, poking and prodding and trying to help the parties exchange information and settlement positions in a way that resolves the case. The mediator normally does this in sort of a facilitative fashion, so that, again, the parties have not hired the mediator to be an arbitrator or a judge and tell them what they have to do, but rather to facilitate the process so that the parties can come to a resolution. At some point, if things reach an impasse or there's a deadlock, the parties might say to the mediator, we want you to switch from being facilitative to being evaluative. We'd like to know what you think. For our own benefit, maybe we want you to tell the other side what you think. But this process is really important, Nate, and this is where someone with like Ed's experience is critically important. In the private session, when the mediator comes in and asks questions about the facts or the organization or the incident, Ed, or someone in his position as the senior client representative, has the facts. Now, it doesn't mean I'm going to present them out in the opening session for a deposition. I don't want them asking Ed questions. But I want Ed and the client representative to be able to educate the mediator to be able to go back and rebut all the points that the mediator came into the room with. That's when we really start to make progress, is when the mediator comes back in and says, I just met with the other side and their lawyer, their number is X, and here's how they justify it, 1, 2, 3. Then the client and the lawyer rebut 1, 2, 3, arm the mediator with more information to go back and give them a number to counter the one that they came in with.
So Ed, let me break down that process. The mediator you're separated, right? You're literally going from a conference room where you may be together, shaking hands, doing this joint opening session, and then you're breaking apart, and you're going in two different rooms that are removed from one another. You have privacy, and you're in there with your counsel and the client and whoever else may be participating in the mediation. And then the mediator, in a form of shuttle diplomacy, is going literally back and forth from the different rooms. And at times there are multiple parties, so you could be sitting and waiting for a long time as the mediator makes her rounds and goes through all these parties. When the mediator finally comes to your room, Ed, how often are you doing the talking, or is it counsel and you're sitting there quietly, or is it a mix of both?
You're on mute, Ed.
That's a great question, Nate. And remember that I cut most of my bones doing union collective bargaining, so I'm well aware. And trust me when I say, notwithstanding Chris and your experience, I've spent many more hours in caucus rooms than you guys have over the past 30 years. So I'm very comfortable with 3 or 4 or 5 hour delays waiting for a federal mediator and a federal mediation conciliation church arbitrator. But again, to answer your question more directly, I am probably a little bit of the PIA client, where I speak more than I likely should. I try not to. I've been doing it for so long, and I know so much. I've been with my company for so long that I tend to talk more directly, probably than counsel and Chris would be included. Enjoy. I don't think I get to the point where it's deleterious to our position, and Chris is not afraid and hasn't been afraid in the past to kind of put his arm out and said, let me get this one, Ed, and he does it with such panache and grace that I always appreciate it. But you guys know sometimes having an attorney as a client presents additional obstacles, and your question is really prescient because that's one of the times when it's probably an accurate statement to say there's some good in that and some bad in that, and it should probably speak a little less.
Chris, I guess it depends on the situation and on the client. When you've got a sophisticated, experienced client like Ed, are you letting him talk or encouraging him to talk to the mediator to inform the mediator as to the facts, or because you want the mediator to see, boy, this is a pretty legitimate individual, and if called to the stand, they're going to make a strong impression? Is it a combination of all those things? And when, conversely, where you may trust an Ed Goddard to handle himself in front of the mediator, are there times where you really have to step in and make sure the client does not say things that would be problematic or hurt the case in front of the mediator?
It really depends on the context of the case and who the client is. For a labor relations case, an employment discrimination case, some other case that we might be working with an Ed Goddard, I want the client representative to be able to speak directly to the mediator so that the mediator goes in with credibility from the client. This isn't just puffery from the lawyer, the advocate, telling his story, but rather Ed, who would be our lead witness in a case, has just informed the mediator factually that this is the case, right? It's not just an allegation, it's like, here's the evidence. So it depends on the witness representative. Conversely, if we're in a different context, we're in a wrongful death case and I've got, the parents of a young girl killed in a car accident, I'm less likely to have them provide factual information because it might be based on emotion, but it also can be helpful to have the mediator see how the family is affected emotionally, and so that he or she can go into the other side and say, you don't want these parents to present to a jury how this has impacted their life because it's over with.
And as the mediator, now you've had the benefit of seeing that. So as a mediator, let me ask you to put that hat on. When you're going in, are you looking to evaluate and hear from a particular potential witness to get a sense of this is a stronger case than I may have thought, or it's a weaker case, and how are you using that information?
It's a great question, Nate. When I'm a mediator, my job is not to root for either side or to help either side win or lose. It's to get the case resolved on terms they both agreed to. So to that end, I want to dig for information with each side privately that I think will help to advance their case in the other room so that it's being considered, that the barrier comes down and the other side is considering it. I then do the exact same thing for that party in their opponent's room. I'm careful to ask, can I share this? If I've heard something that's really powerful, I'll say, that's really powerful. I'd like to share that with the other side. Are you good with that? If they don't authorize me to do it, I can't do it, and I won't do it. But sometimes there's a mid-step approach where I'll say, geez, I just left the other room and I reviewed your position. They're fully prepared to rebut it. I'm not authorized to tell you all the witnesses and pieces of evidence that will rebut it, but I can tell you that they are prepared with a witness on their witness list or an exhibit disclosed in the pretrial memorandum that's going to squarely address this and cause enough discomfort that it affects their position. My objective is not to cause the discomfort, but to let people have as much as possible transparency and full information to make a well-informed decision on a settlement.
How do you deal with a situation where you're evaluating at all times? I mean, you're an experienced trial lawyer, even when you've got your mediator hat on as a sort of conciliatory type of position and facilitating. I have to imagine it's impossible to shut off your evaluative part of your brain. You know how this person is going to appear in front of a jury, good or bad. If you hear and observe information that you think will make for a real change in the direction of the case either way, how are you bringing that bad news to that client? I mean, do you ever find yourself saying to a client, you're just not going to make a particularly strong witness, or letting their lawyer know you've got problems here and that has to be taken into account? How do you go about delivering that kind of message in a way that's tactful?
As the mediator, Nate, you have to be really sensitive to not embarrass either the advocates in front of their clients. So one technique I use is to use rhetorical questions. Rather than come in and say, hey, I just came from the other room and you're going to lose this case. That's not effective. Or to say something to their client that perhaps their lawyer hasn't said already. Sometimes I'll ask if I can speak to the lawyer and outside the presence of their client, just say, I'm concerned about this issue. You may want to just address that with your client so you're bringing it up and it's not I who bring it up. And if I don't do it that way, I might go in and say, I'm hearing both sides of the story, and actually I've just come up with a couple of questions myself that a jury might ask. What do you think about this? Or how is a jury going to look at this piece of evidence? Or do you think that they're going to credit this witness even though the witness is clearly biased because he's a member of the company management team? And let the lawyer work with the client to understand that's an issue that a jury might come up with, and so they can answer it. It's more effective than me saying, this is how a jury's going to find it.
Ed, as the client, are you ever in situations where you're hearing a mediator and you're just disagreeing with their take and the way that they're mediating the case? And when that happens, how do you push back and handle a situation where you think the mediator has it wrong and we like our case better than they do, and to heck with what the mediator has to say? How do you deal with that situation with still trying to keep an open mind and moving towards resolving a case?
Yeah, I'd say, Nate, that's extremely difficult to do. One of the things that's important is getting the right mediator and selection criteria. And I normally would rely on professionals like you and like Chris, because the mediators better than someone like I would. In a labor context, I know the arbitrators, but in mediation. So I think it's critically important, one, that you get a mediator that has some tact and understands their role. Their role is fairly circumscribed, as Chris has described. But I've been in that situation where someone tries to have me take my medicine in the caucus room, and I don't like it. I have had times where I thought the mediator was completely unproductive in his or her approach. and that has not, to Chris's point, facilitated what the goal is, which is to get a mediated result. But I've also had times where I've swallowed my medicine and said, "Yeah, I get that. I'm a little, Chris or someone else will say, I think you're a little blinded on this part." And they have, I've had juries that have bought this line of reasoning and questioning, et cetera, and I think for me, as long as someone gives it to me tactfully, and I ultimately and in the end I take it, but it's a hard pill to swallow, Nate. It really is, because even though I may have not been the one that was accused of taking the illegal action, et cetera, I still represent the company, and I'm personally invested. But it's a skill. It's just like being an advocate is a skill. Being a mediator is a skill, and good mediators can make recalcitrant clients understand that they have weaknesses in their case.
Ed, how important is it that the mediator is experienced in the particular area of law that they're mediating in? Does it matter if that's where their background is, or are you willing to go forward, and have you seen successful mediations with mediators that may not be particularly experienced or familiar with the type of case that they're mediating?
Well, I would say that I'm not that much of a stickler that someone has to be a subject matter expert, Nate. And I go back to years ago, running into a senior counsel, Bob Popio, who basically we said, Bob, how can you be? Chris and I were actually young attorneys meeting him and say, how can you be an expert in all of these different areas of the law? We're so in awe of you. And he said, well, I just learned the rules of evidence and I can pick everything else up after that. And we were like, wow, and so the reality is I just need someone who has common sense, someone who's intelligent and has common sense and people skills, can pick up, if it's IP, maybe Nate. But if it's an employment case, or if it's a general civil litigation and it's not a technical issue, where I would probably desire more expertise. But if it's somebody that's got common sense and tact, can pick it up, and obviously you'd want someone with some level of seasoned trial attorney if it's going to go to trial, right? I don't want someone who's a rookie or has never been inside a courtroom. Occasionally you get stuck with someone who bills themselves out as a trial attorney, and you ask them, and they've taken 5 depositions, but they've never actually done a trial. And you guys are in the business, you understand that really happens. So that's a long-winded answer to say, only in rare circumstances do I think subject matter expertise is critical to a successful mediation.
Chris, I want to ask you some questions about the actual nuts and bolts of the process. So you've got the shuttle diplomacy. We've talked about sort of some of the strategies that go into prepping for a mediation, and then how you're answering questions to a mediator, whether you're allowing your client to speak or the client's jumping in. Once the money starts going back and forth, if we're talking just for purposes of this conversation about dollar amounts, does the pace of that process sort of stay steady throughout the mediation day? Does it pick up at certain points? What's that feel like when you're in the middle of it?
Yeah, sometimes it's hard to get traction. So you'll have the opening statements, parties are separated. Maybe there's, some wounded pride or concern about what they heard in the mediation opening. So the key is to get the plaintiff to make the demand if they haven't made it so far. They make the first move, take that into the defendant, see how they're going to counter it, and that usually goes slowly, as you know. What happens is once you get to the point where the parties are committed to resolving the case, it picks up. Usually when you start getting toward the end of the day that they've paid the mediator for, because they recognize this is their chance to get the case settled. But yeah, you do have to get through the liability discussion almost fully before people feel like, okay, now we're going to just appraise the value of the settlement, and that takes some time.
Yeah, it's important for clients to understand there's going to be a long, slow process, but there's a method to that. And then all of a sudden the dam can break and you can see real progress happen quickly. If a mediation doesn't resolve that day, Chris, well, let me ask it a different way. Do most mediations resolve the day of the mediation?
In my experience, most do. More, certainly the majority of them do. Some carry over, and Nate, I know your practice is the same as mine, which is to keep the door open. That if you've made progress, that's not an end in itself, but it's worthwhile, and that means don't shut down, don't burn the bridge. Try to keep the lines of communication open if it looks like you still could resolve it, It might be that an issue came up in negotiations that it's really dispositive and you don't have the information at that time to respond to it. So you might say constructively with the mediator, listen, we've made progress. We've gone from here to here. But for us to make further progress, I need to be able to evaluate the information you share with me today. I need to speak to my managed personnel, et cetera. Let's maintain our position so we're not moving backwards. We'll work again through the mediator because that's just an effective portal of information going through the mediator, especially if both sides trust him or her.
To continue to use the mediator even beyond day one.
And then, again, most cases settle on the day of mediation. The ones that don't, most settle on some follow-up discussion. And then once in a while, a case doesn't settle despite the party's best efforts and has to be tried.
Yeah, I'm sure you've both seen, a lot of times mediation is about the sort of psychological breakthrough, getting people to start to move towards a middle ground or whatever that may look like for them. And that's the benefit of the mediation. Even if it doesn't resolve on that first day, it does get momentum. From the client's perspective, Ed, do you go in or expect counsel to go into a mediation with a settlement agreement already drafted up and ready to have this thing buttoned up, assuming you can sort of plug and play the terms? Or is it more organic and requires evolution when you're in the process of the mediation itself to be able to fine tune what that ultimate agreement looks like?
Both. I expect if we reach a resolution that we can have a settlement agreement, especially with today's technology, we can have a settlement agreement executed hopefully by the end of that day. I think in my cases, given some of my earlier comments, that there are oftentimes other client-related matters, not just money matters, Nate, that it may be more than just plug and play. There may be some drafting, et cetera, and I'm always happy to assist with that. But the goal is not to just leave with a firm handshake and we'll sign this tomorrow. And then we could do a whole nother podcast on releases and the changing nature of releases and what's enforceable under the NLRA and different state laws and things like that, because that's changing almost daily, and I know you guys keep up with it, and I've lost my fastball on that, but I want it signed that day if we have an agreement.
Chris, are you seeing a change in sort of the trends of how people approach the end of mediation, whether it's a handshake agreement that you've come to some sort of compromise resolution, or is it more an expectation that you've got to button this up, you've got to get it in writing, otherwise folks can change their mind? How does that work at the end of a mediation?
Sophisticated parties and competent counsel will not leave the room without a settlement agreement. Even if you call it an MOU, Memorandum of Understanding, something that recites the material terms and is signed off by the parties is really necessary to avoid like a buyer's remorse. Somebody sleeps on it, wakes up and says, you know what, I'm not going to settle. That makes the whole process a waste of time.
Is that just good practical advice, or what's the legal implications of an MOU that maybe doesn't flesh out all of the terms of the settlement agreement? Those are to be determined. But what happens if you've got this sort of fundamental big picture agreement, but you can't reach the ultimate agreement with the details? Is that initial MOU still enforceable?
So let me start at the beginning, which is when you start exchanging numbers at mediation, as the mediator, I always say, okay, here's their number. I heard you don't accept it, but let's talk about some of the non-monetary terms so that when I go back into their room with your counter number, we can agree. What else do you need in the agreement? That prevents it from being, you think you finally agree on a number, and then they say, well, I want confidentiality, I want non-disparagement, I want general releases, whatever it may be. So I try to introduce those non-monetary terms early in the process. People usually have an easier time agreeing to those. There's some that are pretty standard to a conventional settlement in Massachusetts. And then you're just really going back and forth on the number, knowing you're going to plug it into these material terms. To answer your question, Nate, if you've gotten to the end of the proceeding, you've agreed on the material non-monetary terms, and then you have an agreement on the number, you have a binding settlement agreement. You write it up and you sign it. That's the best way to do it. The next best thing is after you've got it signed, report the case settled to the court. Get a dismissal nisi order from the court clerk. That's going to make it doubly hard for the recalcitrant party to undo this, because now they've got to answer to you and answer to the court.
Sure. All the more reason to make sure that you're introducing those non-monetary terms as early as possible into the negotiations. You can't spring on someone after a dollar amount has been reached. Oh, I also want confidentiality or some other sort of consideration that may be just above and beyond what you bargained for, and it may cost you extra money if you didn't introduce it earlier in the process.
Exactly. Yeah.
Ed, some closing thoughts as we wrap this up. Really appreciate your time joining us today on Trial Think. But Ed, from the perspective of in-house counsel and the client, what do you think is the biggest mistake that clients make as they approach mediation and things that they could do better to put the client in a position, put themselves in a position to be able to get an outcome that's known and that is the result of this process, and not take their chances going forward with trial or arbitration?
I think the biggest mistake that clients make, Nate, is they're still trying to go for a win in mediation, so they misunderstand the nature of what mediation is, um, or they don't define what a win is appropriately. Is probably a better way to say it. This is not a trial where you have a winner and a loser. This is where you have hopefully two winners, and maybe each of you define a win differently. But I think the biggest mistake is thinking this is really akin to a trial. And then I would say to the extent that they withhold too much from their own counsel, I would withhold some at the appropriate time, but you are building, just like when I do an arbitration, you are building a strategy, and everything you say is part of that strategy. And if you don't have the facts to do that, you could end up inadvertently having your counsel trip over your own case.
That's great, Ed. Thank you. Good advice for clients and for people that are representing them to keep in mind. Chris, final question for you as part of the trial think tank. What, from the perspective of the mediator, what is the biggest mistake that advocates make in mediation, and what's a thing that you see done that's very effective and you'd encourage others to do?
Two-pronged answer. First is the lawyers and their clients should approach this as a risk management exercise. That's what it is. Both sides have risk in a lawsuit, and the downside risk could be catastrophic. So as Ed said, look for the win-win when you can get it. I mean, that is a win, a satisfactory resolution that terminates the case and ends the expense and the uncertainty is a win. So that's the first thing. The next thing is, as the mediator, sometimes I see what's called reactive devaluation. In other words, one of the lawyers hears an idea from the other side and automatically wants to shoot it down because it's the other side's idea. To get around this, sometimes as the mediator, if I'm asked to bring something into the other room, I might say, is it okay if I present this as my suggestion? Because they might take it better than this is yours. And it's a psychological trick, but it works.
Those are really helpful pointers. I know one of the best things I've ever heard a mediator say, I had a conservative client who was very emotional about her case, but had been presented with a fairly good offer, but still just wanted to have that day in court and felt like there's more upside here. And there may have been. But the mediator said, I think in a way that was very effective, do you gamble? You may as well just hop on a bus and go down to Foxwoods if you don't take this opportunity to resolve this case, because going forward you could do better, but you could do worse. And it really was an opportunity to have the client understand that there is that component of gambling. We don't know what a jury of 12 people are going to do down the road, and mediation is a perfect opportunity if it's based on an outcome that you can live with, that you feel comfortable with, and that ultimately achieves some of the bigger goals, to have a known outcome, which we've all seen is a really good approach. And it's also a great way to, I think, determine whether the person is and the client is ready to go forward and take on what comes. If you don't resolve the case at mediation, you've got to be able to stomach some real ups and downs as the case goes forward and heads towards trial. So thank you both from the perspective of Chris, the mediator and the advocate, and from the perspective of Ed as a client. It was really helpful to hear your thoughts today. Appreciate you joining us, and thank you so much for your time to both of you.
Thanks, gentlemen.
Thank you, Ed.
Have a good one.
Have a great day.
Thanks for listening to Trial Think. Don't forget to like, subscribe, and join us for all of our upcoming episodes.